We try to do our best to hear the voices of people in Michigan and voices of victims. And I, in response to Representative Gray's comments about felony murder and aiding and abetting, let me just go back and say that two things kind of screening discernment occur. One, when the prosecutor makes a decision whether or not to charge a criminal defendant as an adult, really is part of the degree of culpability and the outrageousness or the seriousness of the homicide. Or every homicide is serious, but the activities and circumstances and facts around it. So every homicide is a serious one. But if it's heinous and even ultra outrageous, that adds to the decision making of a prosecutor, as Jessica Cooper will talk about, I'm certain. And then secondly, there's a jury.
Yes.
And a jury makes a determination as to whether or not the facts and circumstances warrant a conviction.
There's my final question. I don't want to take up the whole morning.
It's all right.
As to recidivism, murderers, there's very little recidivism with murder. Are you aware of that?
Well, I know the recidivism rates in Michigan.
I'm not talking about all. I'm talking about murder.
Well, all I can say that when a murder occurs, it's final, and that death is forever.
But the rehabilitation, the redemption of an individual who has committed a murder, they're not likely to go out and commit another murder. I mean, there's exceptions. I mean, the examples you used showed the lowest and the basest of our souls, the evil in all of us. I mean, the capacity for evil that we all have. When you brought the 3 examples of the homicides and how terrible those individuals acted. But most times, murder is an instantaneous thing. Very, very rarely does is there recidivism with murder.
Well, we know when a murder occurs, and if that person another murder is unacceptable. And I think we just have a difference in philosophy on that, and that's all right.
No, I'm just saying the facts statistically, nationally, on murder. It doesn't happen. 90% of homicides were among people who knew one another.
Yeah. Well, I think that the criminal justice system warrants stiff, tough penalties. I understand that.
Thank you very much.
Thank you very much.
You're welcome, Representative.
Representative McBroom.
Thank you, Mr. Chairman. Thank you, Mr. Schuette, for coming in. I have a series of questions, and I'll go as long as the chairman will allow me to.
I'm delighted to be with you, Representative McBroom. Good morning.
Why, when you talk about this trigger that you'd like to see,
It's just an idea.
Right, I
I'm
understand
giving you
that's-
something to chew on this morning.
but I guess what it seems like, and correct me if I'm wrong, but you're seeming to imply that the minimums then that you would establish in this trigger would be greater minimums than we would have for the prospective cases going forward. And you say 35 years. And so I'm trying to figure out why use 35 years for the retroactive and 25 for the prospective.
They would be the same. I'm just, I'm just providing some numbers to be discussed.
Okay.
And to evaluate in a thoughtful fashion.
And why do you pick, why is 35 in your mind the number you choose rather than 45 or 60 or 70?
I'm just suggesting a number for discussion. It could be higher if you choose, and which I'd not object to. I'm just trying to have a discussion.
Well, I appreciate that, but I guess if the bill sponsor has proffered a proposed minimum as well, why do you disagree with his proposed minimum and support a higher minimum? I just distracted for a second. Ask me that question again, Ed. The bill sponsor is proposing a possible minimum. I believe it's 25 years, if I remember correctly. And I guess
I just think it should be higher. That's just my personal opinion.
But 35 would be acceptable to you rather than 50?
Well, I was just giving you a range. This is, sometimes you have to debate and discuss these items. So I'm just trying to give you some range of discussion. That's all.
Okay. how many other states have or had juvenile life without parole? And have any of those states yet adapted to the Miller case already?
Ed, I'll get you that answer, and we'll probably get it back to you by the time Mr. Bursch comes and offers his testimony here later this morning.
Okay.
And if we can't get it in time, we'll get it to you by the end of business today, and copy to all members of the committee.
Okay, thank you, Mr. Chairman. And just two more quick questions. Did Judge O'Mara, in her arguments about the retroactive, did she consider the Teague case?
You know, Judge O'Mara
precedent?
is a male, and
Oh, pardon me.
whether he, we'll have, John will talk about that. You want to comment on the O'Mara case? Again, I disagree with it, but
I understand, and there's other cases that support your position, so I'm just wondering about his decision. Does he, in his decision, explain why he believes the Teague case apply, how that fits in, or did he ignore that?
Yeah, I actually brought this because I assumed that you'd want to know what his reasoning was. And actually, his entire reasoning is embodied in one footnote in his opinion. And his conclusory sentence at the end is that this should be applied retroactively as a matter of law and morality, which is not really a legal standard that we typically apply. And I would set this up against the People v. Karp decision. That was the Michigan Court of Appeals decision with Judges Talbot, Whitbeck, and Fitzgerald. They wrote a 66-page, single-spaced opinion, a significant portion of which was devoted to the Teague analysis and retroactivity. And I will comment on that some more later.
in John's reference to the footnote in the O'Mara decision is why I was, and I said respectfully, said it was kind of thin in
And,
terms of the legal analysis.
and I guess I'll divide this into two questions instead of one. Is there a,
I'm going to try this approach when next time I'm
Yeah, he's
asking
good
a
at
question.
this.
do you feel like there should be any sort of distinctive difference in the cases that are jury decided versus ones that are not? And was the Miller case itself a jury decision rendered or not?
I needed a reminder, refreshing from John. The Miller case was a jury, and we would not make a distinction between jury or judge.
Okay. And then lastly,
Does this have two parts too? Ed?
no,
I'm teasing you. It's all right.
that's fair. Is when it comes to this whole retroactive thing, and Mr. Attorney General, I'm not saying whether I agree or disagree with your beliefs at this point. I'm trying to assimilate a lot of this and make a decision.
So you're saying I've got a chance? All right.
You can interpret it that way.
All right. Good. All right.
But isn't the ruling in Miller itself, isn't that case in and of itself retroactive?
No.
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 So he didn't get to get a new sentence hearing for himself?
That's different. It does not have retroactive application, Ed.
No, I'm not talking about the decision. I'm talking about the Miller case in and of itself for that individual. It's retroactive to his circumstance.
Yeah,
So
let's.
doesn't that kind of lead us to believe that it should be retroactive to anyone else's in the same circumstance?
But we have it's called court precedent that deals with application of Supreme Court decisions. So that's really the issue that was left undetermined, hasn't been ruled upon, and will come before the courts. And John, add a comment there.
Yeah, as we were discussing with Representative Robinson a little while ago, there's a bright line between someone whose appeal is still pending from their conviction, and the change in law always applies to them. And so in Miller v. Alabama, Miller got the benefit of the ruling because his appeal was still pending. That's a different question than whether you should apply it to folks whose convictions have been final for 30 years.
Right. Thank you very much. Thank you, Mr. Chairman.
Thanks.
Thank you. Representative Oakes has a brief follow-up.
Thank you, Mr. Chair, and thank you again. And just so I'm not misquoting you, it was stiff, tough penalties. You believe in stiff, tough penalties. Correct. That was your statement, correct?
I said that in
Okay.
response to your question. In my opening statement, I was talking about victims. I did not talk about criminal penalties, but I'm always happy to talk about it.
Okay. I guess I want to make sure that we're clear here today as it relates to what we're really talking about. I know you have responded several times with first-degree murder, but I think we're talking about age. And I know, again, when I was a child, I spoke as a child, I thought as a child, I probably acted as a child. But when you become an adult, you put away childish things. In these cases, these individuals were 18 years and younger, or 17 years and younger. I just want to know from your perspective, is there a distinction when it comes to one's culpability based on their age?
Here's my thought. We probably have a difference of opinion on this, Representative Oaks, and that's okay.
Right.
My point is that we need to be able to have an opportunity for a prosecutor to have the discretion to make a decision, depending on the degree of culpability, the facts and circumstances involved in a case like murder, where they can make a decision to try that teenager as an adult. I'm supportive of that. That's my point of view. Others can disagree.
And I'm not sure if you were responding to the question of the age of the child, whether it was murder.
Yeah, see, this is an issue about murder. It's not about age, and this is about victims, not about age. We're talking about a voice for victims and making sure that we have a safer Michigan.
I believe in victims should have a voice. I believe there's a case. We talked about some cases in the media. There's one in the media now where I believe a 9-year-old or 10-year-old killed a 90-year-old woman with a gun, and they believe it may have been based on the fact that he was playing with a video game. Just your opinion, which we all have. Do you believe that 9-year-old should be tried as an adult? There was a murder in that situation.
I'm not, Representative Oaks, I'm not going to get into that. I think my point of view is very clear on today's testimony.
You're about the victims, which I think we're all
Yeah.
are
Well,
about
and
the
I'm glad we
victims.
agree on
Thank you.
that point.
Thank you,
Okay.
Rep. Oaks. Senator Jones.
Mr. Attorney General, one quick follow-up. There's numbers all over here today. I've had people say it ought to be 15 years, 25 years, 35, 50.
Sure.
Now, for criminal sexual conduct of the first degree in a minor, it's 25 years before you can have a parole hearing. Shouldn't it be more than that, logically, for murder?
Well, I think there's a lot of logic to that, and you're in a position to evaluate that thoroughly. Thank you, Senator Jones.
Thank you, sir.
You bet.
All right, thank you very much. I see no further questions from either the House or Senate. So I want to thank you, Mr. Attorney General, for your testimony and
You're
for
welcome.
ably handling all of the questions that we had for you today.
Well, I appreciated being here. Thank you very much, ladies and gentlemen, members of the committee, Mr. Chairman. Look forward to working with you on this issue. Thank you
Thank
very
you.
much.